Alex here with part 86 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I always glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series has to do with providing my viewers with one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We move on to the judge's order. It's an order in judgment. He's given me what I requested. Well, he did that last video too when he ordered a debtor's exam, but he is doing that again now as he is reducing my ex's child support arrearages to a judgment. What is remarkable about this, and I guess I'm going into my mindset now at the time, is that I learned that judges, at least in this particular situation, and at least with this particular judge, their mind can be changed. Earlier, when he struck my request for submission, he stated that, number one, a judgment was superfluous. In other words, he stated I didn't need it, and so therefore, what was the point? And he also stated, number two, that, and I believe there was more to it, but basically he was trying to kind of nudge me in the direction of using the Child Support Enforcement Division. Well, I filed my renewed motion and I confronted him on both of those counts. The first one, I stated that I needed a judgment some certain, and the second one, I stated that I appreciate him kind of nudging me towards the Child Support Enforcement Division, but under the statutes, I had the right to do this on my own, and I was going to insist that I wanted to do it. So the judge, having reviewed my confrontation sort of his two prior points, he apparently changed his mind and he decided to give me the judgment. So he reduced my ex's child support arrearages to a judgment, and I suppose at this point we may as well just go ahead and take a look at what the judge has filed. Here we have the order and judgment regarding child support arrears. In the first paragraph, which is the standard introductory paragraph, the judge indicates that he has reviewed my renewed motion for child support arrearages, my personal service, which was served upon my ex's attorney, and having noticed that there is no response or opposition to my motion, he finds and orders as follows. He goes into the next paragraph and he addresses the fact that a order was entered on June 15th, 2011, that my ex is required to pay $73.91 per month in child support for our son. I am claiming that she is in arrears for the principal amount of $106.23, and I'm asking the court to reduce her arrears to a judgment. He cites DCR 13 subsection 3, which is a local rule that states that if an opponent does not respond to a motion, the court may, they don't have to, but they may, construe their lack of an opposition as, number one, an admission that what it is you're requesting has merit, and number two, a consent that they are okay with the court entering that particular order or judgment or whatever it is that's being requested. So the final assertion that the court makes, or the final statement that the court makes, is that having found that my ex has failed to respond as an admission that my motion is meritorious, he is hereby reducing her arrearages to a judgment, and he's going to set the sum at $106.23 together with costs in the amount of $22.79, and then he's going to go ahead and hit her with penalties and interest, which should come to 15.25%. The last assertion, or the last order that he's making, is that I need to file a satisfaction of judgment within 5 days of the judgment being satisfied, and we'll talk about that when I actually get to that point in the series, because I do file a satisfaction of judgment once she has paid. I just want to tell my viewers that she does not pay voluntarily. I have to seize this money, and that counts as her paying, even though it's against her will. She's technically deemed to have paid, even if the money was forcibly taken from her. Next assertion is a certificate. I don't know why I keep saying that assertion. This is the certificate of mailing. Under Rule 5, the court is indicating that he or his staff member or what is this? Administrative assistant has mailed this document or this order to me and has ensured that it is electronically served upon my ex's attorney. Here we have my notice of entry of judgment. This here controls the timeline for my ex to file an appeal. I'm not going to talk about this in detail, but I'm going to strongly recommend that any of my viewers who have not seen the video notice of entry of judgment watch that video, because it's not just me saying, hey, you've been, this judgment has been entered against you. It's more involved than that. It controls a very crucial timeline, and that is, as I mentioned earlier, the timeline to file an appeal. Certificate of Rule 5 service indicating that I served this notice of entry of order personally upon my ex's attorney, which means I physically took it to the law office and handed it to the lady behind the desk. And I keep saying that, guys, because I want people to know that the word personally has significance. If you state you personally served something, you are specifically telling the court that you walked down there and handed something over. And here we have the final document, which is the notice of hearing. And in the notice of hearing, I'm just telling my ex the date and time for the debtor's exam. And just so you guys know, this isn't something that I just kind of dumped on her. I didn't just come up with this date and time on my own. If you watch my previous video, you will recall that we filed a notice to set. Now, at that date and time, in the notice to set, we conferred, and together we came up with the date and time of the actual hearing. And that is what this is here. The notice of hearing follows the notice to set. And the notice of hearing is the date of the actual hearing itself. That's when we're going to conduct the debtor's exam. And you can see here that I'm also citing a couple of statutes indicating to my ex that her appearance is mandatory and that the failure to appear is a contempt of court. Interestingly enough, most of contempt is discretionary, but failure to appear at a debtor's exam is specifically mentioned in a statute, and that is NRS 21.270 subsection 3. The legislature enacted a statute stating that if you have been served an order to appear for a debtor's examination and you fail to appear, that may be punished for contempt by the judge issuing the order. I realize it still uses the word may, which is discretionary, but I imagine that ties into it something like they couldn't appear because they got in a car accident or they got hospitalized or something like that. It is just noteworthy that the legislature specifically addressed this particular act of defiance in its own separate statute. It's not even located anywhere in the contempt of court statutory scheme. It's under the proceedings supplementary to execution statutory scheme. So it was important enough for them to add that law to really underline the fact that they do not want people to just ignore these orders. They have to go and they have to be examined. That being said, I want to go into the examination now because unfortunately, debtor's exams, at least in Nevada, are not recorded. And maybe it was because it was before the discovery commissioner. So maybe under other circumstances they are recorded, maybe they're just transcribed. I'm not sure what the situation is. But in my particular situation, this debtor's exam was held before the discovery commissioner, and in his courtroom, there either is no JAVS video recording or for whatever reason he does not have these specific types of proceedings recorded. So I'm going to have to kind of give you guys the best recollection that I have of this hearing because I'm not going to be able to play a hearing video. Going into the debtor's exam, I felt very comfortable, and here is why. At the time, I worked for a collection agency and had already seen a number of debtor's exams done in the past. In fact, we had a list of questions that we used at work when we subjected debtors to debtor's exams. So I just took my experience and that kind of knowledge and I fashioned a list of questions for my ex to answer at that particular debtor's exam. The list of questions was simple. I needed to execute on her assets, and the two big ones that jumped out at me were number one, her bank account, and number two, her wages. Those are the two that I think are the easiest to get from the average everyday person. You can also try to put a lien on a home. You can try and tow their car away. You can try and take their furniture, their jewelry, their furs. There's all kinds of things you can try and take, but those things are really tough to take, and they also, you end up fronting a lot of money to even try and do something like that because you end up having to pay ahead or in advance for the tow truck to go tow their car or the sheriff to show up with a writ of possession and take their furniture and stuff. The cheapest and safest bet is typically the bank account and the wages. Those do require some fronting of some costs, but it's much, much lesser, and they're also much more successful. Now, this involved me asking her questions like, where do you have bank accounts? What are the account numbers? How much money is in each account? Where do you work at? Things like, how much do you make per week, per 2 weeks? When do you get paid? Little questions like that. And the other thing that I want to mention is, if you do subject your ex or your opponent, if you're an ordinary case, to a debtor's exam, please take this opportunity to ask questions that you already know the answer to, but you aren't sure. The reason why is because any answers that your ex or any other opponent may have given you may or may not be true. And especially if they're based on research, because then you're not even getting it straight from the opponent. You're getting it from some other source or the internet or something like that. The reason why you want to ask questions, even if you already know the answer to them or suspect you know the answer to them, is because the answers that are being provided to you now are under oath. They're swearing under penalty of perjury that what you were suspecting was true is actually true. There were a few situations where I asked my ex questions and she was annoyed. She told the judge he already knows the answer to that. And the judge just eyeballed her and said, answer the question, ma'am. And he didn't even explain to her why. It's like he didn't have time for that nonsense. You were asked a question. It was relevant to your assets. Answer the question. He didn't care that I already knew. And she was very reluctant to give those answers because, as it turned out, I wasn't quite on point with what I suspected. And so she was trying to find a way to dodge a question without lying under oath. So once she answered the question, I realized, oh, I guess I was wrong about that. This is where her accounts actually are. This is where the money actually is. This is how much is actually in that account. Once she was confronted with the threat of committing perjury, she ended up telling me more truth than I had ever known before. And this is something that you want to do at a debtor's exam. Take advantage of the fact that your opponent is under oath. Another thing I want to mention is that a debtor's exam is a one-way examination from a judgment creditor upon a judgment debtor. This means that only the judgment debtor is placed under oath. The judgment creditor is not there to answer any questions. The judgment creditor is only there to ask the questions. So when we went into court and the clerk stood up and said, please raise your right hand and be sworn, I deliberately did not stand and did not raise my right hand to be sworn in. Number one, I knew that this was protocol because I was the judgment creditor. And number two, I really wanted to let her know that this is not a situation where we were coming in on equal footing. I wanted her to know that her little antics of deliberately not paying child support just because she thought she could get away with it were, putting her into this position where she was being subjected to a debtor's exam because of the consequences of her own actions and her own choices. When I didn't stand up and raise my right hand, she gave this kind of gasp or strange look, I guess you could say, like a look of shock. Like she thought the judge would say something or that the clerk would say something, but nobody said anything to her. So I think it unnerved her a little bit to see that. Anyway, moving on to, there was two other things that I want to mention about the debtor's exam. Number one, she resisted telling me her social security number. Now, the reason, I'm going to make a general statement. Generally, people are not entitled to know your social security number. That is a private piece of information. But that is just general. Yes, no random person on the street is allowed to know your social security number. But there are certain exceptions to that particular rule. And when you are a judgment debtor and you owe money to a judgment creditor, the judgment creditor is entitled to know your social security number. That's not just any run-of-the-mill person that's asking for the social. That's me, a creditor, asking for the social because I need that social security number to seize your assets. She did not want to give me that number, and the judge initially was going to force her to turn it over, but she relied upon her confidential address program, and the judge ended up doing some research, and he found out, or the judge, the discovery commissioner ended up doing some research, and he found out that the VA hospital would allow somebody's assets to be seized without a social security number if certain information was provided. And so he was, I'm not really annoyed with him. And in fact, he ended up making up for this later on because I subjected her to a debtor's exam a few years later. And that time he forced her to turn over the social security number. Either that or he held her in contempt of court. I can't remember now. One of the two happened. We're going to get to that point in my docket series. It will come up. But the point is, eventually her fictitious address was canceled. And he noticed that and he reacted. He basically stated that Because she's no longer a member of the confidential address program, the Supreme Court of Nevada has intervened. They revoked her fictitious address. She was no longer able to claim that she was a victim and all that other nonsense. And then at that point in time, he was prepared to order her to turn over the social security number, or he held her in contempt of court. One of the two things happened. The next thing that I want to mention was there was a particular incident that I do recall that I guess I could tell my viewers about. Unfortunately, we don't have a video. I would love for you guys to see it. She initially did not want to sit down at the desk because she was claiming that she was scared of me. And the clerk was like, "What are you talking about? We're in a courtroom. There's a bailiff here. There's no reason for you to be scared here." And my ex was insisting she didn't want to go in. She wanted to wait outside until the judge got there. And the clerk got really, really furious with her and like stomped out of the room and got the judge and stomped back in. It caused a huge scene, and my ex was really embarrassed by it. I think she imagined that she was going to get some kind of special treatment, and she didn't get any special treatment at all. In fact, they treated her like just any other judgment debtor, and when she tried to resist being subjected to the examination, they treated her like they would any other judgment debtor who tried to resist, which is basically, enough with your nonsense, answer the questions or else. Going into the aftermath, I didn't file, let's see here, I did file two of these documents, the notice of entry of order and the notice of hearing, but they were both free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney actually didn't go to this debtor's examination. Apparently, she and my ex came up with this agreement that to save attorney fees, she would just go on her own without her attorney. And so I think that definitely reduced the attorney fees a lot, but I don't imagine that her attorney did not at least review and email some of these documents to my ex. And I imagine the notice of entry of order and the notice of hearing were reviewed and emailed over to my ex. And the order and judgment was especially, I think, important for my ex's attorney to really communicate to my ex what that entailed, because that's a big red circle around that judgment, because that unlocks a lot of tools to me. I can start to issue writs of execution, I can start to issue writs of garnishment, and as we proceed in the My Docket series, you will see me levy my ex's bank account and issue a writ of garnishment upon her employer. And these are things that the attorney, I'm sure, wanted to really warn her about, and I'm sure that her attorney told her, you should just pay this $100, it's going to be a lot cheaper for you, because by not paying that, she's going to get hit with the interest and penalties, and she's also going to get hit with the accrued costs, which end up probably dwarfing the principal amount itself. So I do think that probably 5 minutes for both of those notices and 25 minutes for the order in judgment, which will take us to 30 minutes, half an hour, at the rate of $250 an hour. That will bring my ex's attorney fees to $125. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.